So, welcome everyone to my second MBL webinar, and today we'll be talking about two relatively juicy topics in the wills, trust, and probate sphere, and that is undue influence and fraudulent calumny. I say juicy, but also highly relevant, because we have seen this year the Law Commission's proposals and bill for a new Wills Act 2025, which incorporates a change, well, we'll see if it's truly a change, to the law of testamentary undue influence. The aim of this talk is to provide a reminder of the key principles of undue influence when dealing with wills, and a unique area of fraud in the context of wills, namely fraudulent calumny. The aim is to also set out some key procedural requirements, particularly given that the allegations of undue influence and fraud are extremely serious allegations. I also intend to set out those key principles and procedural requirements in context by way of an application of a case study based on one of my cases that I did last year. And I'll also explore the key challenges a legal practitioner in this space is likely to encounter and the ways in which those challenges or hurdles can be overcome. So I therefore intend to take you all through the following. The first is substantial validity as against formal validity. Undue influence and fraudulent calumny allegations fall within the confines of a challenge to the substantial validity of wills. Whilst I don't intend to go into any detail on this point, I intend to remind the audience of the distinction between challenges to the substantial validity of wills as against the challenges to the formal validity of wills, and why that distinction matters, and is one to frame your preparation of your cases on this area on. I'll then set out the key principles of undue influence, and the key principles and the meaning of fraudulent calumny, before considering a key procedural requirement of undue influence and fraudulent calumny, which is effectively, in my view, a measure of gatekeeping whether the case is a runner or not. I'll then examine a case study, discussing key evidential requirements, challenges and hurdles one might encounter, and how those challenges can be overcome. That will then follow with a brief visit to the Wills Bill 2025, as I mentioned earlier, to determine whether, if the new law on testamentary undue influence was to be adopted, whether this would bring about a change in the way we handle the case study. It would appear that fraud and fraudulent calumny has not been put on a statutory footing, or is not intended to be put on a statutory footing.